we want to be respectful of time, though. Why don't we get started? Matt and Randy. Okay. Why don't we get started? So this event is going to be live streamed, and I do appreciate all of you that are in person. So all of you get like a little extra gold star. Good job.
And cookies and extra
Yes, you're welcome. Thank you so much for joining us. Okay, so today is the first of our awesome AI-related series. This one is AI and Ethics, Navigating the Legal Landscape. That sounds so official. And today I want to introduce Paul McLaughlin. Just stand there, smiling. Hold your applause because I have a whole bio. So ready? Okay. And this was written by AI, so it's totally accurate.
Perfect, very fitting.
Paul likes long walks on the beach. I'm kidding, Paul. Also, I've seen this guy present a few times. So okay, and I'm sure by now Paul knows my humor. Paul is a partner at Atkinson, Andelson, Loya, Rudd, and Romo. Paul represents school districts, county offices of education, community colleges, and private schools across California on labor, employment, governance, and facilities issues. He routinely appears in administrative hearings and related litigation on their behalf. He brings a particularly timely perspective as a leading writer and speaker on technology and education, covering topics like AI policy for schools, privacy in the age of generative AI, deepfakes, web accessibility, and even student cell phone videos in teacher discipline cases. Before entering practice, he clerked with the Cancer Legal Resource Center and served as an extern to a federal bankruptcy judge. And he now also gives back through board service with the Hope for Marion Foundation, and he is also an adjunct professor at Pasadena City College. But he loves Saddleback better, correct, Paul?
No comment,
Okay.
no comment.
Please join me in welcoming Paul McLaughlin. So just a few housekeeping items. Paul loves to be interrupted, so if you have questions or comments, you want to throw in the occasional boo, right?
Sure, keep it spicy.
We can do that. I will have a mic, so if you in the audience have a question, just let me know and I'll come around. And then for all of you that are watching on the live stream, just put it in the chat and then I will be keeping an eye on it. So without further ado, Paul McLaughlin.
All right. Thank you, Kim, and thank you for being here. I really appreciate it. I can't really say much better than that. That's one of the best intros I've ever had, so thank you, Kim. Yeah, so we're, no pressure, kicking off the Artificial Intelligence series with a notorious wet blanket as an attorney. That's kind of what we're trying to do, but my hope with this presentation is that I give you more food for thought. And like Kim said, in addition to practicing law and working kind of in the educational technology field, I'm also very cognizant as what you all do in the community college world, just as an adjunct. It's given me a new perspective and actually really enriched like how I approach things, especially with my community college district clients. So I speak from some experience here as an instructor, and like Kim said, I prefer questions in the middle. Don't feel like you have to hold everything till the end. Chances are if you have a burning question, someone else has a similar burning question. I like to say we're in the trust tree here to give a Meet the Parents reference. You can ask a question in a safe space that I hopefully will have a decent answer for you. So please, by all means, do so. I think that's everything. My main housekeeping thing Kim already covered with questions. The only other thing I'm just going to add onto this is that I am a product of the community college system on top of that as well. So really proud of that. So what are we going to talk about today? Just everything artificial intelligence related, everything you're ever going to need to know about it in 2 hours from a legal perspective. Unfortunately, no. This is a really rich, complicated, and fast-moving, fast-paced environment. We're seeing things. There's a saying in the law that the wheels of justice turn slowly. We're notoriously about 5 years behind the technology, and it's really been exacerbated with artificial intelligence because it's moving incredibly rapidly. Not to take you to your phones or give you any sort of distraction right now, but has anyone Googled or gone on YouTube and seen the video, Will Smith eating spaghetti? Does that make any sense to anyone? Well, I encourage you afterward to go onto YouTube and check it out. The reason I bring it up is in 2023, someone fed into generative AI at the time, make me a video of Will Smith eating spaghetti, and it's comically bad. It's laughably terrible. It's the weirdest thing you'll ever see. But now that we're in 2026, people have fed that into generative AI in 23, 24, 25, 26. Now it's incredible. You would never know a difference. It looks like the cinematography is great, interacting with other people, having an actual meal. It's all with Will Smith eating spaghetti. But that just gives you a sense of how fast this is all moving. So we're trying to keep up as attorneys just with what the legal landscape is, what court cases are looking like, what legislation looks like, and giving some educated best guesses where we can about where this is all going to go. So I'm going to give just a brief overview of generative AI and how it's being used in higher education. From what I understand here at Saddleback and Irvine, y'all are ahead of the curve. You know more than a lot of people do about the actual application and use of artificial intelligence. So I'm not going to spend a ton of time on that. But I will be talking about emerging challenges and legal issues, things that we've issue spotted. And we're going to spend a little bit of time focusing on a couple of issues in particular, like ethical use and equity considerations. We're going to be talking about copyright and intellectual property and how that's really been in effect, both from student work as well as faculty work. And we're also going to focus in on privacy considerations. That's probably our number one concern from the legal perspective about what's going on with the use of artificial intelligence. So after that, I'm just going to give you, it's towards the end on purpose. If we run out of time, we are together for 2 hours. If we run out of time, I put new laws and legislation at the back. I will have this available, and it should be available to you to look after the fact. So you can look at all my slides about what the new laws and legislation are. And then we're going to talk a little bit about policy development and best practices. South Orange County Community College District's AI policy is fantastic. I put it on 2 slides just to highlight it, and I encourage you to go check it out on your own if you haven't already. It's doing things that we're supposed to be looking at. It's looking at things we're supposed to be looking at, excuse me. So just some consideration about how to implement those sorts of ideas into your day-to-day here on campus. And then I put Q&A at the end technically, but like I said, please ask questions throughout. I'm happy to answer them. We'll pause and talk it through. All right, so just really quickly, some overview of AI and their uses in higher education. This is the perspective I start with globally. What's AI, like where is it, how are we approaching it, especially in the United States? It's being looked at as a potential extinction event to businesses. That's why you're seeing a lot of these really bad, honestly, apps that everyone's thrown out there that are either generated by AI or have AI as part of their features, or both. And it's because every business is now seeing it as part of their revenue source. This is something that we evolve or die. Like, people are taking it incredibly seriously, not just for new AI businesses, but ones, all of our existing companies that we're aware of. They're just trying to change with the times, trying to get with it. So it's seen as an extinction event just from a marketplace perspective. All right, so this is my first quiz, and by the way, there's going to be a few quizzes throughout. They'll hit you when you least expect it. So there will be some times where, especially my folks in the audience, I'm going to put you on the hot seat. But this is my first question. Who knows the person on the right? I see a few hands. Does anyone know who the person on the left is? Okay. So the person on the right, several hands went up. Does anyone want to share who they think? Sam Altman. Who is Sam Altman? He is the founder, basically the guru for OpenAI. They're the ones who run ChatGPT, who all of our students and all of our fellow employees are using. They're the primary, when we think of generative AI, we think of ChatGPT. The person on the left is Johnny Ive. He is a very famous industrial designer, really came up through the ranks with Apple. So that's what he's famous for. So these two, if you haven't heard already, they're in the process of developing this technology where I find it a little creepy. I think a lot of people do. But what they're envisioning, this is a prototype kind of model of what their AI vision looks like. They see it as something that's as ubiquitous as a companion to like your cell phone, basically your cell phone. That this is something that's going to be as ubiquitous and used as your cell phone. What it is essentially an AI view of the world that's wearable or that you have on you at all times. Has anyone seen the movie Her with Joaquin Phoenix? I see, that's what I kind of envision this. That it's an AI future, that there's really no holds barred. There's always going to be a camera. There's going to be enhanced reality. That's what Altman and Ive are looking at very seriously right now. So this is kind of the next big thing that's coming. So the reason I bring it up is just because it marries a lot of these concepts when we talk about AI, traditional versus generative, and what that device looks like. That is an example of what we're seeing as a marriage between the two. So what are we talking about when we're talking about traditional versus generative? So traditional are the things that we've kind of experienced for years. Things like GPS, a Google search, that is a form of artificial intelligence. It's things that they're performed tasks that require human-like cognition. It's basically a call and retrieve. So a lot of these really traditional types of technologies that we're all very much used to, like it drives me nuts. I have a 13-year-old. She, as part of her daily routine, will ask ChatGPT like what she should wear that day, or what's like that is how we all saw like Google at some point when we were younger, right? It's become ubiquitous to kids, especially. So that's where that mindset is. With that generation, they're living really with generative AI. Generative AI, just in a nutshell, is supposed to mimic human cognition. It's supposed to mimic thinking as best as we can. And that's where we get the ChatGPTs of the world, things like Gemini, Grok, all those traditional thinking type of artificial intelligence technologies are generative AI. It's producing some sort of output based on an input that's supposed to resemble thinking. Now, something emerging that you may or may not have heard of are these concepts of agentic AI, conversational AGI, and artificial general intelligence. Does anyone know any of those terms? You want to share any one of those three you can pick?
Well, artificial general intelligence, that's sort of like the holy grail. That's like human level intelligence.
Yes, so the answer about AGI was this is the holy grail, this is like human level intelligence, that's exactly right. AGI is kind of the end game about, this is someone where they would not pass the Turing test, essentially. You would not be able to tell you're talking to a computer. It's supposed to mimic intelligence, computation, complex thought in real time. That's sort of like conversational AI, but it doesn't have that complex level of thinking about what's really next. Conversational AI, it's kind of what you think. It's not prompt and output. It's more real-time feedback, like you're having a conversation, right? Agentic AI, that is the concept that you have like a ChatGPT output, but there's independent thought about what task to do next. And there's no specific prompt about, how many folks use ChatGPT? Be honest, safe space. All of us, right? I do it with my lectures, and I always, with policy, check what the output is and give my own feedback. But agentic AI, when we're using ChatGPT right now, if we're asking to put a presentation together, usually at the end it'll say, hey, would you like me to put this into this format? Would you like me to put this into 15 slides? Do you want me to make this colorful? Agentic AI is like having that follow-up prompt, but just in real time, that they're using it on their own, essentially. So agentic AI, conversational AGI, these are all things that we're starting to hear in 2025 as we move forward into 2026. That's really the focus. Now, I tease my wife. My wife's an attorney as well. It's a fun household. She actually does contract work, training an AI, generative AI, to do legal work. And I kind of look at her like, why are you putting us out of work? She said, it'll be 10 years from now, we'll be fine. What the sophistication that we see with these levels, and I'll tell you, just as an aside, what I see her inputting and what gets put out, it's something that a second or third year attorney can do. It's amazing where the technology is, and it's going to be everywhere. All right, so we've already gone over this, so I'm not going to belabor the point. Okay, what is significant about this big 2,739 I'm throwing at you? This is the average number of ed tech tools that are used per district, K-12 or CCD, per year, according to a study. So we're thinking about apps, different kinds of tools, just anything and everything you could think of from a tech perspective. That's kind of the average, based in California, of what's deployed in any particular agency. It's everywhere, right? It's in everything we do, every task that we do, what our students are doing, what our staff's doing, it's everywhere. So I only throw that number out there just to really drive the point home that this is something that's not going away, it's everywhere. So how is Gen AI being used in higher education? I mean, I've broken this down, kind of giving you a laundry list of things that I've seen, things that I've heard from faculty, staff, student, and information technology perspectives. The number one way that I've been personally seeing it is from a faculty perspective with helping, I use it and a lot of my colleagues use it to condense and summarize written material. I think that's how a lot of our students are using it as well. Faculty are also using it, in my experience, just to generate presentations, lectures, et cetera. It's just an incredible time saver. That's what we're already seeing deployed. We're seeing students do the same thing with test prep. We're seeing them use it to summarize text. We're seeing it in all sorts of different ways from our students as well. Unfortunately, we're also seeing it with student work that's being turned in and not read. I think at this point, we're all looking for the M-dash, right? The telltale sign of the ChatGPT output assignment. But I bring it up, it's being used, if you're not thinking about it already, just on campus by everyone. So these are just some examples of what we're already seeing. All right. What is the significance of what I'm throwing up at you now? So this is just a chart, visual chart about 18 to 24-year-olds. Who's using ChatGPT and how often, based on percentage of use. So you'll see 18 to 24-year-olds who are interviewed as part of this study. In California, we're one of the top 5 states where this is being deployed by young people, by 18 to 24-year-olds. California, Arizona, I don't know why exactly, but the point I bring is that California, it's something that is, it's being used by young people all the time. I bring up the example of my 13-year-old, not to tease her or make fun of her, but that's seriously how it's being used. It's being used for everything you can think of, which leads to the next infographic. Now, it's a little misleading. I hate infographics this way, but it was the best I could do. The top is 50%. It's not 100%. So these are responses from 18 to 24-year-olds. How are you using ChatGPT on a day-to-day basis? You'll see a lot of the traditional ones up top, but look at the ones with the gray bars below. And if anyone wants to say what really sticks out to you. Yeah, that might help. And I apologize, it's so small. I will say, I'll just give it up because I can barely see it. I apologize for that. You'll be able to zoom on it when you get it at home. Essentially, mental health. It's incredible how many of our young people are using AI to help them with their mental health. And there's nothing wrong about it. There's nothing that's alarming about it other than how is the technology being responsibly responding to these sorts of inquiries. So this is the generation that's behind me, certainly far behind me. Our young people, our early 20s and younger, they're using it for everything that they do in their life. So mental health, dating advice, relationship advice. One of the ones that you can't see on there that I'll tell you is health. They're asking for diagnoses. It's like the WebMD for AI. So people are using it for everything in the generations behind us. So it is everywhere. So some of the things you may not have thought about that are moving towards the future about how we're using these things in an advanced manner, just listed them out for you here, and I apologize that they're small. But just some of the ones that I wanted to point out. I got this actually, I was on a panel about a year ago with another faculty member who taught art. And she was using AI to do vibe coding. Does anyone know what vibe coding is? Yeah, you want to give us a definition?
You put a prompt into the computer, and the computer generates the code for you.
Yep. I think that's a good succinct definition. So vibe coding is where you put in a prompt and the output is code. And I've seen it, and this person on the panel with me was using it to create an app. She was vibe coding to create an app. And she was doing amazing things in her courses. The art that was being produced, she showed me some of it. But that's just one example of this very advanced use of this technology that's already going on in some people, with some people. So some of the ones with the one with students that I wanted to just point out is that we're seeing things like completing entire assignments. Not to bag on our students, but unfortunately, it used to be here and there, at least in my experience. I don't know if anyone feels differently. In my experience, it's been a problem, where we're seeing just no thought, no creativity, no even fact checking. I don't know how you all address your students. I tell my students, I expect you to use AI. I'm not going to put my head in the sand and forget about it, but at least put some human thought into it, look at the outputs. It still falls flat with a few students, but a lot of them do take it seriously, thankfully. But we're just seeing it more and more. All right, so just, again, some real benefits that I've seen in higher education in terms of uses of AI. Grading and assessment, huge time saver for all of us. Providing constructive feedback on concepts, things that you may not have thought about. It's a good thought partner, which I know sounds creepy, but AI can be. It'll give you 3 good ideas out of 15, but those 3 are very useful. And so that does provide some good constructive feedback that you can give to student work, to what your colleagues may be doing. Deployment of chatbots, we're already seeing it and seeing it successfully. I bring up the University of Murcia in Spain and SUNY, I forget which campus in the state university system, I apologize. But we're seeing these chatbots that are being deployed to answer questions that are considered quote unquote low level at about an 80% success rate. So that's what these 2 studies are indicating, that they're deploying them on their campuses with that success rate. So I just thought it was pretty interesting to bring that out, but chatbots are becoming more and more common. Student grading and evaluation, personalized learning. This is a concept that is really more heavily focused in K-12, but I just bring it up because I have seen it deployed, where you may have a student who has shown an interest in a particular subcategory in something you may be teaching, that you may be able to give them something more personalized that doesn't take a lot of extra time, that's something special or important or unique to them. Sentiment analysis is actually kind of a creepy one. I'll give you an example. Arizona State University, about 2 or 3 years ago, they were trying to analyze data, and they were trying to figure out, well, what's going on with this sentiment analysis. Really, it picks up on behavior and characteristics and then makes predictions. It's like predictive analytics, you may have heard of. Arizona State was able to calculate with a very high success rate how students were failing based on the swipes into the dormitories, like the times. They were tracking all that, and they were able to figure out with a pretty high success rate what was going on with those particular students. They did it from a purely positive point of view. They're trying to help students. But that kind of picks up on one of these ethical considerations we're going to be talking about in a moment. Like, do we really want that? Is that ethical that we're tracking that information? Has anyone in the room heard of the CSU, this Cal State pilot program that's been deploying chatbots? Just in a nutshell, there's 3 campuses in the Cal State system that they're using academic coaching to enhance student comprehension. So it combines several student tools like chatbots, reading assistants, with instructor resources. They kind of marry those 2. They have found that this has had success with student achievement, but on top of that, it's also scalable. So they're thinking about deploying it more system-wide in the Cal States, but they're also seeing, what we're seeing a lot of is, distance education. How are we reaching more people? So this pilot program has been declared a success, and so they're actually exploring a little bit more what they can do with it. So, one of our focuses, and something that's been a real positive over the last decade or so, is a focus on equity in education. How are we making education more accessible to the greatest amount of people? So AI has been successfully used in some of these ways as a tool to empower students with disabilities, people with learning differences, it creates accessible training for teaching diverse student populations. It's a way to give education, make it more accessible to a wider group of students. So there's personalized AI, these kind of like personalized learning systems that we're talking about helps in that regard. Predictive algorithms, they have been found, and these are based on studies, that they often replicate racial biases in educational assessments, unfortunately. So there are positives, but there are some drawbacks, and we'll talk about a lot more of those drawbacks later, just things to be cognizant of when we're deploying AI and thinking about how we're delivering instruction or assisting students from an equitable perspective. So there are some impacts on racial disparities in education in a positive light. We're going to talk about more of some of the risks and how we can address those in an effective manner in a little bit later in the presentation. So AI can help address systemic inequities in a number of ways, right? It democratizes access to personalized learning, creates adaptive learning pathways, it generates culturally responsive content in a lot of situations, provides academic assistance 24/7 to students who work off hours or just need access from anywhere. Distance education, it's been a really positive impact that way, offering real-time language support and feedback. So again, all the positive stuff before I hit you with the more negative stuff later. Just in the interest of time, I'm going to get moving. So just some common gaps that we're seeing with the deployment of these technologies, just to be aware of. With identification, assessment, and policy, these are all things that I just want everyone to be cognizant of as we're talking about these. Identifying a problem, assessing the problem, assessing students' performance, their feedback, et cetera, and then policy perspectives. How do we address it effectively afterward? So if you take anything away from just our conversation today, other than like doom and gloom or like weird stories, take a look at the end of the presentation especially. It's just a lot of food for thought about how from a policy perspective are we addressing these issues and how can we do so effectively. All right, so this is my first test for you today. There's going to be a few of these throughout. So, was this photo made by AI? Who says yes? Anyone? Okay, I see about half the hands in the room. Anyone say no? And Kim can't comment because I think she's seen this before. So this, no. This is one of my colleagues took a picture in Sedona, and I just think it's a really good picture, so I put it in. But I bring these up because I think we're all kind of that mindset that we're always like questioning and looking for these sorts of things with artificial intelligence, right? I think we're all very much trained to go there and to start thinking about it. So just really emphasizing how much we're in our daily lives thinking about these sorts of things. Okay. So next part is kind of just flagging issues for you. A lot of what I'm going to talk about, we're just starting to see these issues work their way through the court systems. And we're starting to see things from the perspective of a lot of our governmental agencies who are watchdogs over a lot of these processes to make sure that we're using things in a responsible, non-discriminatory, legal manner. So these are some of the emerging challenges and legal issues that we see. So I just wanted to bring up a few cautionary tales first, just to highlight some of the main things that we're seeing as problematic with AI. So this first one, it's about chatbots and how much stock we put into answers that are generated by chatbots. This particular case is an Air Canada case. There was someone, I guess in Canada, I think it's a government-sponsored policy where you can get discounts for bereavement travel. So this gentleman went online, he asked a chatbot, hey, if I buy this ticket and after the fact, can I get my bereavement discount? Chatbot said, sure, not a problem, go for it. Gets on his flight to Toronto, goes back, asks for a refund. Air Canada says, no, you have to do that before you take the traveler or do the purchase. So he was out about $600. He was motivated enough to file a claim against Air Canada. I bring this up because what was Air Canada's main defense? These are just attorneys. You shouldn't trust what chatbots tell you. That was their main defense. The Canadian court said, we're not gonna go for that. If you're gonna put this product out there as the equivalent of a human being speaking to you, they need to be giving you correct answers. So the reliance on chatbots is just a real world example that these are things that we can't always rely on, but the courts are starting, at least in Canada and other places, and we're gonna talk about, especially about the European Union, really addressing these sorts of issues. All right, another cautionary tale, and this has to do with hallucinations. Has anyone heard about hallucinations? I'm sure most of you have. A hallucination is basically false information that's put out by an artificial intelligence system. So there was this story that came out, I think this was about a year ago. AI generates false BBC News headline. Do you wanna know what the headline was? It's about Luigi Mangione, and the headline was Luigi Mangione had shot himself, not the CEO of United Healthcare. So the question became from the BBC, actually, and a lot of people in the UK, to Apple. That was what Apple's summary was. If you Google search Luigi Mangione shooting, that's what Google put out there as this is a summary of what, or not Google, it was Apple. This is a summary of what this story, of this situation. It's completely wrong, right? It's a hallucination. We're actually going to talk about a few hallucination cases that are working their way through court right now. AI is grabbing a lot of people on social media and unfortunately on the internet who are perhaps gullible or taking things at face value. The Goodbye Meta AI hoax. Does anyone remember anything about that? Things move so quickly on social media. I tend to just ignore it because, you know, why? But there was something going around on Instagram and Facebook where people were saying, oh, if you put into a post, Goodbye Meta AI, it meant that AI was not allowed to use my content to train AI systems because Meta had announced any person over 18 years old, we're gonna train our systems on our material on Meta platforms. So people started sharing it. Tom Brady was a very famous example of someone who did it. James McAvoy was another. It was completely made up. You can opt out of Meta AI by saying Goodbye Meta AI. But it's just an example of misinformation, how easily it's spread. Some people speculate that Meta created that hoax in order to get more data. It's a little bit like the Barbra Streisand effect, right? Let's highlight this problem, we're gonna pretend to ignore it, and by doing so, we're gonna get more focus on it. So just another example of AI being used inappropriately. This one, you know, I say because it's becoming a major problem in the legal world. You hear it all the time, attorneys relying on AI-generated information. Their first case that was very famous came out of New York City. It was a very big law firm, Avianca Airlines, and there's some $1,000 hour attorneys that were defending a lawsuit. They submitted a brief, and the brief had completely made up citations to cases that did not exist. They were embarrassed out of court. They probably had a hard time justifying their hourly rate after that. We're seeing it everywhere in the legal world now. And these are, again, hallucinations, but has anyone had the experience with ChatGPT just making things up and then calling them out on it and then saying, oh, I'm sorry, I'll do better next time. They just want to give you information. They don't care where it comes from or how it comes. So there was a case I just read out of a reporter last week that there was a summary judgment motion where the opposition was made up completely of wrong citations. They lost a $100,000 case as a result of that because the judge threw out their paper. They said, this is meaningless, I'm not considering it. So it ended up being like an unopposed motion, and it ended up in a $100,000 judgment. So highlight it because this is creeping into every aspect of what we do as professionals as well. And then lastly, government regulators are starting to question AI's content. The UK, Europe, China actually is taking things very seriously. It seems like every country other than the United States is really heavily questioning what AI is doing now. And the UK is taking this particular look into how Microsoft is taking screenshots and learning based on screenshots of what they scrape off the internet. So it's a big privacy concern. Unfortunately, here in the United States, privacy is not taken as seriously as it is in the European Union and China and a lot of other countries based on what's online. So a lot of these questions are starting to come up, and privacy is a major concern. So there's a lot of legal and logistical challenges that we're facing. This is all needless to say, right? So some of the bigger ones are understanding how to use the powerful functions of AI. It's a very powerful tool. It's very helpful. It can help us in a lot of ways, but it's also, with great power comes great responsibility, right? That's our, to me, major logistical challenge, probably our most serious one. What do we do with information generated? How are we relying on it? Should we rely on it 100% wholesale? Should we have a human on the other side checking things out? Does that kind of defeat the purpose? A lot of these questions pop up as a result of the use of generative AI, but what do we do with the information? How do we take it? How do we store it? How do we share it? There's a lot of questions surrounding that. Concerns about cheating or plagiarism and academic integrity with higher education, that goes without saying. I think one of our primary concerns, if not the primary concern, about how our students are using it, especially. And then we're going to talk about a whole host of legal issues. The ones we won't talk about or focus on are concerns about job replacement. We're seeing a lot of, just as a side note, our friends in labor at the negotiations table are really upset and scared about AI, understandably, because they're seeing it from a job replacement perspective. We get it. All right, so we do have some drawbacks. We'll get down into a lot of these in a little more detail in just a moment. But I wanted to highlight again, hallucinations, a major one just to be really cognizant of, because it's just become more and more of an issue when we're not having people check things that get submitted. There's a lot of ethical considerations we're gonna go into about perpetuations of bias, because after all, these machines are human created and our biases are built into them. Something that's not a legal challenge, but a lot of people really struggle with, is this loss of human interaction and overall reliance on technology. How much should we be relying on this technology? What should we be doing it? I was just listening to an audiobook. I had a lot of downtime recently that was talking about its whole theme was, how do we thoughtfully disconnect? And that's in 2026, just an interesting concept because we're constantly connected. So how much ethically should we be really relying on these technologies? All right, so just jumping into the specific concerns. AI and academic integrity, obviously a major one that we're thinking about. We operate with a lot of traditional academic integrity policies. The ones in addition to other things, I do a lot of presentations with the Chief Information Security Officers Association in California. And there's an exercise I was doing a few years back saying, I want you to all go look at your acceptable use policies and tell me the last time they were updated. Someone found one from 1990 something. They were still talking about facts, they were talking about microfiche, they were talking about, it was crazy. But I bring that up now to really say, like, what do your current academic integrity policies say, and how are we able to fit that into the use of AI? Are they able to fit into it? Updated policies need to be accounting for generative AI tools. So there is a case working its way through Massachusetts, the Massachusetts courts. It's in the K-12 context. But what had happened is a student had submitted work that was very obviously, according to everyone with real knowledge of the case, AI generated. The student was making several arguments as to why they got a 0 on the assignment, and so about why they shouldn't have gotten a 0 on the assignment. One of their arguments was it wasn't clear that I couldn't use AI, which kind of begs the questions like, okay, so you're admitting that you used AI, but it's one of his like arguments in the alternative. But it's an interesting question, right? It's something where he wasn't specifically, explicitly told he couldn't use AI to assist him or be any part. So What should a clear academic integrity policy include? That's a really important question, and that's one of the major questions in this lawsuit. Still making its way through the courts. It's on appeal right now. But I bring it up because this is from our business department. This is just a chunk of it. It's much longer. But I put this in my syllabus each semester to be very clear that I know you're going to use AI. It's fine to use AI, but here's the specific ways that you should use it, specific ways you should not be using it, and red lights, like what I'm not going to allow you to do. I did my online training certification last year, and one of ours was to put something like this in. My instructor said that's one of the most just insanely long ones I've ever seen. Tone it down a little bit. I took a little bit of exception to that, but these are things that you really should be thinking about to put students on notice. And if you have it in your syllabus, you could check out mine, check out anyone at Pasadena City College. Their business department has a great one. But if you're not putting this into your syllabus, or at least setting these expectations early, I'd really encourage you to do so. Just because it cuts this argument off, and you can tell students clearly when you should, shouldn't, and can't. Okay, so employment discrimination. This is one that has been working its way through the courts. This particular example I bring up is called iTutor Group. So the EEOC, they're the body who oversees, it's the Equal Employment Opportunity Commission. It's the federal body that oversees discrimination in employment situations. So people can file complaints saying, I was discriminated against any one of this number of protected activities. Well, someone who's really clever said, you know what, I'm going to test out iTutor Group because I know that they're using generative AI to look at resumes. So what they did is they took identical resumes, and they put one in for men, women, under 40, over 40, and they just saw about whether or not those resumes were accepted or rejected by AI. What they found was that women over 55 and men over 60 were getting rejected outright. The identical resume for someone who was a woman under 55 or a man under 60 were being accepted. You can't get more of a clear discrimination case than that. So what happened as a result, EEOC fined the group $365,000, and they had to change their policy, obviously. So we're seeing things from a discrimination perspective in this regard. AI needs to be trained. It sounds crazy, but you can actually give bias training to AI. You can give discrimination training to AI, and it's something that really needs to be taken into consideration if you're deploying this technology and you don't have a human fact checker on the other end. All right, major one, misinformation and defamation. So these all go back to, again, hallucinations. So this one particular case that I bring up, OpenAI, they failed to escape their first defamation lawsuit as a result of AI. So what that means is someone filed a lawsuit for defamation. He was a disc jockey in Ohio, and there was a hallucination that came out that he had been convicted of embezzlement in his past. He absolutely had not. It was completely made up. So he filed a lawsuit against OpenAI, and the question became, would a reasonable person consider a ChatGPT summary a quote-unquote statement of fact? That's one of the major elements of a defamation case, if you state something as fact, that it's truthful. And the courts said, yeah, you have to be taking that as a statement of fact. We're not going to toss out this lawsuit just because your product stinks. So I also bring it up because OpenAI, they actually have disclaimers. If you really want to drill down into it, if you're really bored or need to fall asleep, they warn users not to take ChatGPT's output as accurate all the time. So it begs the question, when should I ever take it as accurate, right? So these excuses are not flying. That Air Canada case didn't fly. It's not flying here. So these companies, they just want to get product out. They don't care about what the output is. They just want to make money. So anything that's put out by generative AI just needs to be really scrutinized. Okay, algorithmic bias and discrimination. If this doesn't sound 21st century, I don't know what does. So this concept that we have about bias and discrimination being built into systems, just because it's online or it's built into generative AI, it still exists. And the reason that we talk about it is because these are all systems that are, at the end of the day, human created. Humans, unfortunately, bring their biases into the electronic world. So these sorts of issues do exist. We're seeing these biases and discrimination playing out through the use of artificial intelligence. So we do have some guidance about what constitutes discriminatory use of artificial intelligence, generative AI, and what we should be looking out for. So the Office for Civil Rights is the federal, it oversees the enforcement of federal civil rights under various titles, Title 6, 9, Section 504, Title 2. They're the watchdog. You can go file a complaint with OCR and they'll come in and do an investigation to see whether or not these things are true. So when they put out guidance, we listen loud and clear because we know that that's what they're going to be looking at. So they put out some guidance that they have highlighted some key areas of concern when we're talking about discrimination. So plagiarism and AI detection. There are potential biases against English learners in some of these tools that say, hey, you use our tool, it's great, it catches these AI-generated content pieces all the time at a higher rate than you do. There's actually a study that found out that they don't. Human beings and AI are about the same success rate at detecting AI-generated. But anyway, the reason I bring it up is because it's been demonstrated that English learners are discriminated against based on detecting plagiarism, because English learners are more recently learning rules of grammar, how to, they're learning a second language, so they're more cognizant of that. These tools are flagging them as cheating. So we're seeing that discrimination and bias, so there's things that really need to be paid attention to. Facial recognition, it's a form of AI. They also risk misidentification based on race or ethnicity. There's been a lot of studies shown on that. Test proctoring, they have to accommodate students with disabilities. We think that we can deploy something that's automatic, that'll just proctor examinations, but they do discriminate against people with disabilities. They flag certain things that may look like inappropriate action, but they actually aren't. It's just a student with a disability who may be doing something a little differently than what the norm looks like, quote unquote. Sex discrimination, Title IX complaints have been hitting the roof. One of the things that we're seeing emerge are deep fakes. So people generating content that's obscene based on single frame pictures, and you can scrape a soundbite off the internet and generate fake content. And unfortunately, it's mostly in the K-12 arena, but we're seeing some in higher education where people are creating sexual content that way. So deep fakes are something of great concern to the Office for Civil Rights. And then lastly, scheduling systems. There are certain ways that scheduling systems might have equitable issues about through gender, through programs, through any number of protected characteristics. How are we using these scheduling programs in a manner that doesn't discriminate against any one particular protected category? So just a quote from the Office of Civil Rights. They have to protect students in educational settings. That goes without saying. I bring up OCR, the second bullet point, to say OCR status has really been in flux with the Trump administration. And I can say that from real world experience. I had existing cases with the Office for Civil Rights. January 2025, all those people stopped responding to me. I don't know who's actually working and what they're actually focusing on, but it's certainly not the cases that I was working on. So it's a little bit unclear what some of the enforcement mechanisms look like right now, just based on where we are. Okay, so digital equity, this concept that we have, President Biden issued an executive order saying, hey, if we're going to be deploying all this technology, we need to be doing so in such a way that we're ensuring equitable access, that we're not discriminating, that we're giving everyone opportunity to access technology equally. So there have been some studies that have shown how equitable concerns are being raised through the deployment of these technologies. Again, just more examples of what we might call discriminatory behavior. So ChatGPT, GPT-4o, in a study where they looked at 13,000 8th to 12th graders and state standardized exams, were discriminating by giving lower scores to Asian American students. you see at the bullet point at the end, the bias was unexplainable. They could not figure out the root of it. But I say it's just an example of the algorithmic bias that we're building into these resources. Again, it's all human created. Predictive analytics is also something that has been criticized because they are impacting different groups of, especially people of color, in ways that are unfair, that are discriminatory. So predictive analytics is taking a data set and figuring out where, based on the knowledge that we know, where the certain outcome is going to be. And so there have been some ways that these have been deployed in a manner that has been discriminatory against certain groups of certain people based on protected characteristics. So there's a now somewhat infamous example from a university in the South that was flagging people who were in pre-med and rerouting them to nursing based on success rates, and they were flagging men and men of color in a way that was discriminatory. It was pushing them out of pre-med in a way that was not fair. So again, digital equity concerns just to be cognizant of, because these are things that we're deploying, not thinking about, but that's built in, baked right in. All right, accessibility. Accessibility is becoming a focus because I have started seeing claims going through DPSS where students are now going and saying, I need to use generative AI because of my disability. It should be an accommodation that you should be making. And I've seen a few instances where that accommodation has been made. And the question is becoming like, well, what's the limitation that we're addressing? Like, what are we addressing by this use? And there's usually not a great answer. It's hard to assess through the interactive process when a student, quote unquote, needs to be using generative AI. But I put this up there because there are a lot of protections for both employees and students in higher education under federal and state law that we cannot be taking any sort of discriminatory action based on a number of protected characteristics, but disability being a big one. So these accessibility type issues are a major focus. Web accessibility is another big one that's going on right now. A lot of Title II, a lot of Section 504 of the Rehabilitation Act. There's a lot of protections for people when we're talking about accessibility from a disabled person's perspective. Okay, one that we're a little worried about that's kind of weird. I don't know how much you all think about the Public Records Act on a day-to-day basis. I think about it more than I care to because we're just getting a lot of them. The volume of them, the complexity of them is just amazing. The problem that we're having is how do we address what generative AI are those public records? And based on the definitions under the Public Records Act, I would say yes, they are. So a lot of us in the legal field are taking the perspective that inputs and outputs are both public records. That if someone made a search for, if you didn't have an exemption that you could put on there, it's otherwise a public record. So when we had emails come out, when I said the wheels of justice turn slowly, the Public Records Act actually didn't mention emails for a very long time. But when we started using email on a prolific basis, we didn't really account for how much email we generate. Same thing with Public Records Act and generative AI. Like, we're producing lots of records all the time. So just something to think about. Okay, here's another quiz because I've been talking about legal stuff for a long time. I have two quotes here. One that was done by the Supreme Court of the United States and one that was generated by ChatGPT. So if you just look at these two, I don't know if anyone can tell the difference between the two or anyone has strong feelings one way or the other. That might be a little hard to see. But if we just took the one on the left, does anyone have any strong feelings that it was the United States Supreme Court? So the one on the left that was human beings. That was actually from Bush v. Gore in the hanging chads and all that stuff that we all remember from, unfortunately, the late 90s. So again, just the sophistication of what we have is just amazing. People get these on about a 50-50 success rate when I give presentations. Okay, so I had mentioned earlier, I was going to go a little bit deeper into a couple concepts just because I think they affect us like more often, and we're thinking about them a little more often. One of those is intellectual property and copyright. Something that we're always, we're trained in online certification to be cognizant of copyright and attribution, things like that. How does generative AI play into that? And that's been a major question, both under federal law and working their way through the courts. So I'm giving you what is on the books. And the thing that jumps out at me right now is the Copyright Act of 1976. So we're now at the 50-year anniversary of the Copyright Act, which is going to apply to things that are generated by artificial intelligence, all right? So copyright protection covers original works of authorship fixed in any tangible medium of expression. That's what the statute says. Attorneys write these things. They're intentionally vague. It's so we get paid more to argue about them. But that's what we have on the books. Original works of authorship fixed in any tangible medium of expression. That's the lens we're looking through when we're talking about copyright issues. What's not subject to copyright protection? So this is, again, right out of statute. In no case does copyright protection for an original work of authorship extend to any idea, procedure, et cetera, in which it is described, explained, illustrated, or embodied in such work. So again, kind of confusing, right? But the concept that something like an idea, a procedure, a process system, something that's not tangible, that's not going to fall within the realm of the Copyright Act. It's going to be more like an intellectual property idea. That's where that law is, that's what that law is protecting. So copyright, intellectual property, the concept being tangible versus non-tangible, things that human beings create, and that gets important in the end. So what rights does a copyright give the owner? Basically the right to reproduce, the right to profit from it, the right to perform and display the work. This is what happens when you own a copyright. It gives you a lot of protections, and it protects against people's unauthorized use of it. So copyright infringement is one who reproduces, publicly distributes, publicly performs, displays, etc., a copyrighted work without authority. So you have to give attribution, you have to get authority, otherwise you're going to be infringing on a copyright. So why am I bringing all this up? Because, not to bore you to tears, but because we're now on this concept of copyrightability of AI-generated content. The creative machine. What is AI creating? And how does it impact intellectual property, copyrighted ideas, and works? So we have a couple of clues. And so Thaler versus Perlmutter is one of them. It's a case that came out of the DC circuit. So a lot of these copyright cases you'll see come out of the federal court in Washington, D.C., because that's where the Copyright Office is for the United States. So anyway, an individual in this case created an AI system to generate images. So they had made the system that didn't take any particular inputs, but had ideas created. Not to sound like a gigantic nerd, but our Dungeons and Dragons group, we use something like this to generate our characters for our sessions. Anyhow, that's the concept. Put an idea, this is what I'm thinking I want, put it into the machine spits it out. I'm not giving an image, I'm just putting in what I want it to look like. So this person, they sought copyright protection over the images that were created by that machine. So they claimed that the machine itself was the author. So this computer was the author of this work. I gained ownership, copyright ownership through work for hire. Essentially, I hired this person to create this for me. Therefore, I ought to get the copyright. So what happened, the court disagreed with the individual. What they said is an author means one that is the source of some form of intellectual or creative work, otherwise known as a person. That begs the question with AGI. You know, we have these sentient beings, not too far off in the distant future, perhaps. Is what they create going to be creating an author where they're generating work? This court is now saying, nope, anything that comes out of a machine, that's not a person, not copyrightable. A human has to be the originator to claim copyright protection. So the court denied the argument for the AI-generated works that were to be protected in that particular case. So the more important question, I think the one that affects us more often, is what about using copyrighted works, not to train AI in particular, but what we're doing, we're putting in copyrighted material to maybe get an outcome. When is that okay? When is it not okay? So we're having some clues in these cases that are coming out. So this case that I bring up is this case, Westlaw. Westlaw is the biggest database for legal systems, cases, statutes, et cetera. It's what we use when we actually go on a computer to do legal research, if we're not using Google. So that particular case involved someone using Westlaw copyrighted material to train their own database. They were taking copyrighted material, putting into their generative AI process and hoping for an outcome. So Westlaw, which has $1 bazillion and can hire those attorneys, they sued this little company saying, no, you can't do that. So they trained their AI with these copyrighted works. They made a fair use argument. Fair use is something that you could say is put out by someone who holds a copyright that's put out to the public with the intention that it can be generally used by the public. So that was the argument they made, is that, well, this output, like I only trained it using things through fair use. And the court in that question did not agree with that. So that's actually a duplicate, sorry. So with respect to that, the prompts themselves, in that case, they were copyrighted material, so they said that the output was also copyright protected. So just thinking from this perspective, if it's something 100% generated by computer, probably not protected. If you're using copyrighted material to generate content, the output itself is probably going to be infringing on someone's copyright if it's protected material. So with respect to AI-created works, they may be copyrightable, and there may be situations where we're able to make that argument, right? So if an author inputs their own copyrighted material and it spits out something that was based on your own copyrighted material, likely the output's going to be copyright protected because the input came from a human as well as the output. So the same copyright protections ought to flow from what was put out. If AI work is used in larger human-generated content, the output may become part of the overall copyrightable work. So I would say, just as a general rule, if you're going to take anything away from this particular conversation, be very aware of what is being put into generative AI. Because if it's copyright protected and you don't have the rights, you don't give attribution or you don't have the rights to use it, the content that is put out may subject you to not only copyright infringement for using the material in the first place, but the output is not yours either. So that's just my general take on it. That's how these cases are seeming to rule and seeming to shake out. Okay, so aside from IP and copyright, et cetera, the main thing that we as attorneys have been worried about with respect to our clients who are working in education is privacy. And what are we putting into generative AI that may be protected by a right to privacy that we're violating? So remember when I was talking about the Public Records Act? That becomes important for this conversation because if we're using things that are infringing on privacy rights, then unfortunately that may also be something that becomes an issue later if there's a Public Records Act request for something. Okay, so when we're talking about the general right to privacy, we're talking about a few things. The Article 1, Section 1 of the California Constitution says this is the most important right that individuals have in California. Just interesting, right at the very top, it talks about a right to privacy. So it expressly protects it in California. The Fourth Amendment in the federal Constitution does as well. So in order to have a privacy right, your expectations have to be reasonable. Your expectations of privacy can be reduced through certain ways, but when we're talking about what we do, the main concern that we have are student records because we have these protections that exist under federal and state law. So we have FERPA, and then we have a bunch of sub-regulations under FERPA that talk about what is protected, what you can and cannot use in terms of student information. And we also have it in the California Code of Regulations as well. So the definition of student records is very broad. So we can only be using student records for an educational interest. We can only be sharing educational records amongst colleagues when there's an educational interest as well. The main thing that we're concerned with FERPA protections is if you're using open source AI and you're putting student information into that content generator, you've essentially engaged in a FERPA violation because that student did not consent to that being put into ChatGPT or whatever. So the reason is because that's open source, publicly accessible. That data is going to exist somewhere where it shouldn't. So what we've been having certain clients do is if they've created their own system and it's closed universe, that gets around this problem. And so we're looking at it as this is being held by the institution, it's not going anywhere. I'm allowed to share it with colleagues for an educational interest, for mutual educational interest. Therefore, it's not a FERPA violation. So that is the main reason that we talk about FERPA in particular. Because if student records get out in any sort of way, educational records, then that's going to be a violation of federal law. Technically, a FERPA violation puts your federal funding in jeopardy. I've never seen federal funding get completely taken away from any institute, but it's technically on the books.
Paul, can we ask a question?
Yeah.
Great. I have a question. So when we talk about, to the previous slide, so GPT-0 is a new platform that's to detect AI use, right? So if instructors are to put a student's work in there, would that be considered a privacy issue? And then to follow up, if they removed the student's information but still submitted just the work, does that count?
So interestingly, the second question answered the first one. So that's exactly right. So if you put something that's an identifiable piece of pupil information, put a student's name and attribute their work to it, and you put it into the machine, yes, because that is their educational record that has identifiable information. PII is what we call it. If you anonymize the information and you put it in, and there is a way that you can sufficiently account for someone not being able to piece together, that's a real technical term, what that is, then you've sufficiently anonymized that data that you are not creating a FERPA violation. So that's a really great question, comes up. FERPA violations, the main thing we're concerned about is identifiable pupil data. So if you anonymize it sufficiently, and this is how we get around things with like data on testing and how we're getting institutional-wide data is we're pulling off student ID numbers, we're pulling off everything else. When we have just raw test scores or raw material that we're working that's generated by a student, that's okay. That's not a FERPA violation because you've anonymized it. Yeah. Okay. So what are not educational records? We have this concept of directory information within FERPA. This gets a little bit nuancy about what is okay and not okay to put into something that's open source, but there are technically things that are not considered student records for FERPA purposes. So just know that if you have something that's considered directory information is something that's not considered an educational record. If you release it, it's not a FERPA violation. But if you combine it with other things that are protected, then the whole thing becomes protected for privacy considerations. So that's where you just really need to be careful about using student information. By the same concept, same token, the fact that with higher education, we have student clinics, we have health information that's also stored on campus. Technically, you're also a HIPAA-covered institute for that reason. The fail-safe that I give is if you're following FERPA, you're basically following HIPAA as well. So same concept, if you're talking about medical information about someone, should not go into some sort of open source because you're releasing that person's protected private information. All right. So there's a few different ways that you can limit someone's privacy expectation, and this is just more food for thought. At the beginning of this section, I was talking about, hey, we have these great big protections, but you can also limit it. One of the main ways that you limit it is you give someone sufficient advance notice, and they voluntarily agree to engage with whatever technology or limitation there is in terms of what they're interacting with. So with policy, if you're talking and you're upfront and clear with people about, hey, we're using AI for these particular purposes, and we may be, if you interact with it, you use it in a certain way, you're consenting to having your information, or you're consenting to, otherwise, for us to use information that you may otherwise expect to be private. That's a way that you could potentially limit the privacy expectation. So if you want to be deploying the technology, as long as you're upfront with people and they have a way that they can reasonably consent with it, chances are you're going to be able to address those privacy concerns. Okay, another quiz. Was this photo made by AI? Who says yes? I see more hands than my Sedona picture. Anyone say no? One hand in the back. You're very brave, yes. No, this photograph was not generated by AI. I'm not trying to trick you. It's just, I picked intentionally pictures that kind of look a little like, I'm just curious, and I don't mean to put anyone on the spot. Any volunteers want to say why they thought it was AI? Yeah.
It just looked really, really smooth. Too perfect.
Yeah, the comment was it looked really, really smooth. So you know what? I'm going to give you half credit, because what if he used a filter? A filter is kind of like, yeah. So you know what? Everyone's right. I'll give you all full credit. Congratulations. Okay, so now just switching gears. So we're going to talk about some new laws and new legislation that we have, and then we're going to end with some policy. We got about 45 minutes left, so I think we're good on time. So ADMT refers to automated decision making. So it's the deployment of a system that makes decisions automatically. It's basically AI making decisions. So when we talk about ADMT, we're talking about a lot of privacy concepts and having to make people aware of when we're deploying it. That's been a lot of the focus of what's come out in the last year, is making people aware about when the technology is being deployed and how it's being used. So this CPRA is not the Public Records Act. This is the California Privacy Rights Act. Rules were finalized July of this last year, 2025. So this just addresses this big concept in the law. It was very broad how they defined ADMT under the prior Privacy Rights Act. That technically was anything that automatically makes calculations, decisions, et cetera. So technically, a lawyer made the clever argument saying, well, if you put an Excel spreadsheet and put a formula in that, that's a form of ADMT under this definition. So that's why they've changed it. So now it's defined as technology that processes information to replace human decision-making or substantially replace human decision-making. So that's going to drive a lot of the privacy rights that are going to be going in throughout the state. A lot of these other laws are going to be going back to this definition of ADMT. So I only point it out because you may see it in other aspects of your life as well, that you're going to start, remember when we all started getting cookies notifications a few years ago when we were visiting websites? We're going to start seeing more of this kind of stuff, because we're going to see a lot of resources using automated decision making, and now it's going to have to be known that those technologies are being deployed.
Question on that one.
Yeah, question.
So basically, potentially anything that uses agentic AI would be subject to that new law for ADMT.
Yeah, so the question was anything that looks like agentic AI would be subject to the ADMT disclosure laws. Yes, you're absolutely right. So anything that mimics thought, anything that looks like you're replacing a thought process or you're using it to generate something that resembles thought, yeah, it's going to be subject to it. So any of those technologies that are deployed, it's going to fall within that new definition. Okay, so we have a new-ish White House AI action plan. So the federal government took an interest with AI, and the Biden administration at first put out some generalized rules and concepts that they would like to see followed with the deployment of AI. the new administration walked a lot of it back. And I mean, it's just kind of the ebb and flow of politics where we have a more conservative administration rolling back a lot of what looks like regulation, right? So the new White House AI Action Plan, it follows the removing barriers to American leadership and AI concept. So it seeks to remove a lot of red tape and what they call onerous regulation. Interestingly, it threatens funding cuts to states. We've seen a lot of that in the last year about threats to cutting federal funding to states that seek to restrict AI. California is one of those states because we've passed legislation that restricts it in such a way by making people more aware that it's being used. So that's how that's been interpreted. It attacks ideological bias. What exactly that means, I don't know, but I think if they're looking at systems that they deem to be too woke, I know like Grok was put out as the savior of more conservative AI. I think that's what they're getting at. They're trying to say, well, things that exhibit an ideological or left-leaning bias is what that statement's meant to be, in my opinion. It's seen as a repudiation of recent developments in the EU. We're going to talk about how the EU's developed or addressed AI and why we're talking about the EU in this room. I'll give you that in a moment. But there's also no mention of copyright law. I don't know if that's because they felt there were sufficient protections already baked in to federal copyright law, that they didn't need it, but they just ignored it. They didn't talk about it. And they talk about fewer environmental regulations. So famously, AI uses a lot of power, someone once told me, I don't know if it's true or not, that every ChatGPT search costs 1 bottle of water to cool down servers. I don't know if anyone did the math on that. But that's what they're addressing when we say environmental regulations. So they're walking a lot of that back with respect to the amount of technology that it takes to run AI. It takes a lot of energy. So just a quote from the White House, the AI czar, that's what they self-titled it. We believe we are in an AI race and we want the United States to win that race. So that was the whole perspective behind this AI action plan. Okay, so recent EU action. So if you've not heard about the General Data Protection Regulation before today, I'll just give you just the high-level overview of it is that the EU has this for all of its member states, a privacy regulation set of laws that apply to data, how individuals interact with data, how data is stored, how people have individual rights in their data. The reason we're talking about it in this room is that the EU takes the position that any EU citizen overseas or abroad, that the GDPR applies to them. I don't know where they're going to enforce it, but that's why we are cognizant of it, because we do have international students here, right? So what the EU has done, the GDPR has been on the books for several years now. They also came out with this concept of AI, saying, well, just because AI is a game changer doesn't mean it nullifies or negates the GDPR. All the protections and the protection regulation apply to what you're doing in AI. And that's kind of a big concept because AI has really run amok over the last 2 years with how they're treating data and how they're interacting with it. So it's just that there's going to be this AI Act that the EU has put forth. We're going to be enforcing it fully. So one of the EU's AI spokesman said, let me be as clear as possible. There's no stop the clock. There is no grace period. There is no pause. So right now, immediately, this AI Act was put into place. We're giving no leeway to people, to these tech companies and how they are deploying this technology. All right, so the U.S. Department of Ed has come out with some guidance about federal grant funds in AI and how that's working. So they say that districts, K-12, community college, et cetera, they can utilize existing federal grants to support AI initiatives. So there was some question about how federal grants could be used, and they're saying, well, yes, we're saying clearly that you can. All right, so we had some carryover legislation from 2025 that I just wanted to make folks aware of. There is a Senate bill that was passed called the Workplace Surveillance Tool. It addresses workplace surveillance tools. So it's a requirement that an employer annually provide notice to the Department of Industrial Relations. That's the state agency that oversees a lot of the labor laws that we have in California. that workplace surveillance tools are being used in the workplace. So it's just another notification requirement. We have a lot of those protections kind of baked in already because we're subject to collective bargaining in California, and so that has been made known to at least all of our covered employees that if we're using surveillance tools, they've been careful to propose it in bargaining, or they've already negotiated it into contracts that we as the employer have to give notice that it's being used. So we're mostly taken care of, I think, in practical part by this legislation. So AB 1015, automated decision-making systems. So this is what, with the ADMT, if it's being deployed, a covered automated decision system, if it conducts impact assessments or provides consumers with certain information, basically if it's being deployed by anyone who's and consumed by anyone who's consuming that information, whether it's a product, business, et cetera, you have to be giving information that the system's being used, and you have to give a quote-unquote high-level summary of the results of those impact assessments. So if you're using AI to make any sort of study or assess how things are working in the marketplace, then a covered entity has to be making that notification. So like the example with cookies that I was talking about in ADMT, you may be seeing more of this just in your day-to-day life as well. Okay, another automated decision-making systems law, SB 947, prohibits employers from using automated decision systems to perform certain functions without human oversight. So basically, you need to be having a human on the other end to be making sure that these decisions are being made appropriately. Okay, so this one is addressing a lot of what we've been calling deepfakes, a lot of those issues that we've had with people using AI to do inappropriate things. So Senate Bill 926, it amends the Penal Code, California law, to criminalize the intentional creation and distribution or conduct causing the distribution of any one of these harmful type images. So if you're using deepfakes in any sort of way, you could be criminally liable. So these issues have popped up with student discipline cases. We've seen some on campus, including in colleges, unfortunately, through Title IX complaints and things like that. It's now a criminal law on the books in California that you cannot be engaging in that behavior. I don't know why we need to have that to tell people that that's a wrong thing, but we have it now. So it's now criminal protection. All right, another one. Was this photo made by AI? So how many people say yes? Got a few hands. Any no's? All right, I think you're on to me. So no, this photograph was not generated by AI. It's just a really cute cat. So I would have thought the same thing. If it's a little bit kind of blurry, it looked to me when I first saw it that it was, but I put it in here because I was actually really surprised that it was a real photograph. Okay, I only have one more of those, I promise, at the very end. And I think you'll like that one, the one at the end. All right, so just to round things out, we're talking about policy development and best practices. So I've given you all the doom and gloom, wet blanket type attorney stuff about why AI is problematic. I just want to be clear that AI is a great tool. It can be used effectively and it can be used responsibly. And to me, through policy development and best practices, we're going to get there. And so that's why I encourage the adoption of generative AI policies for various reasons. Sets of expectations for AI use on campus. It gives very clear, at least general guideline, and then you can get more specific, either in your own class, your own department, et cetera. It ensures compliance with law. Reduces exposure to liability by establishing safeguards as well as expectations. You're telling people you're deploying the technology. If you have consistent application of rules across all your campuses and departments, even better, something easy rules to follow. It provides a basis for training and enforcement. So if we're able to have a policy, learn from it, and go off it, we have a nice consistent way to approach it. That's the benefit of having policies. So just some ways to develop those kinds of policies. If you have cross-functional task forces, you map existing AI use, you kind of learn, you gather intelligence about how it's being deployed, who's already using it, you're gathering stakeholder input and concerns. You can develop comprehensive policies that way. Just more information, the better that you can start addressing all of these uses and how things are being used on campus already. So if you're going, if we're talking about developing policy, we need to consider several topics, right? To do what we're doing on campus, we're going to primarily, in my opinion, have to address like how students are using it and how we're treating students. So student data privacy and security is a huge one. And that's why we talk about the FERPA protections. That we have all of these privacy regulations specific to students as well as generally in California that are really important for us to be protecting. And that we have to be using this in a way that data is going to be secured. One of the talks that we were given a lot more about 5 years ago, and now everyone's like really on it, is data breaches and how things are handled when we have those sorts of events. There's been a lot more focus on it, and how we are storing and treating data is a key component of that. So if we're talking about how we're storing student data, how we're keeping it secure, it's important. Yeah, you had a question?
Yeah, so if you already have existing ARs and VPs that address all this, data classification, data retention, why do you need to have a specific AI policy? Because when browsers came out, when the internet came out, there wasn't any specific policies that were written for those, or when the calculator came out, it just started stretching it,
Yeah, no, I mean, it's a good question about why have a specific policy when you have a bunch of different other policies that address the kind of conduct. I would just answer it in a couple of ways. The main thing is just the way that this is being deployed and it's everywhere. I think necessitates a specific policy. But to your point, I think a good AI policy just borrows and refers from other policies. So I'll give a shout out to Miracosta College. Actually has a AI policy that does exactly that. It says here's a bunch of different categories about what we're looking at and thinking of, and here's how we're borrowing from this BP, this administrative procedure, et cetera. I think it's 3 pages. It's not this unwieldy 20-page document. It does a lot of borrowing from other places. So that's I think addresses your question that it borrows from existing law. You don't have to recreate the wheel, but you're also using existing. So like an academic integrity policy, for example, I'm sure you have one on the books, but I'm sure it also doesn't specifically address AI. You can say this policy does apply to the use of AI, and here's some additional pieces to it. Just one example. So you've done a lot of this work already. But yeah, all of these things really talk about where AI is touching. So like academic integrity, acceptable use policies. If you've taken a look at that recently, that's another good one just to revisit. Ethical use, digital citizenship, non-discrimination, bias, you have those policies already on the books. Professional development, training, and monitoring, all these sorts of things are just food for thought about what should go into a policy or what your policy should be referring to. That's already on the books. Okay, I'm gonna just jump ahead a little bit. Okay, yeah.
Okay, so this is in the live chat, and I'm going to read this the best I can. Okay, it says, with regard to human in the loop, or HIL, do you foresee a percentage liability judgment like 60-40 AI human? Out of 100%, AI is 60%, culpable human is 40%.
I'm going to be vulnerable, and I don't know I actually haven't heard of that. Can anyone answer the question? Because I think it's a great question. I know I'm putting myself out there as a tech expert. I haven't heard of that.
Can you specify what human in the loop, HIL, is? Let's see. No, not you. Not you, Paul. Okay. We'll look into it and get back.
Okay. Yeah. I mean, I can guess at what it is, and then we'll see what gets back. It kind of goes back to a best practice, and actually kind of dovetails with the slide a bit. In any kind of situation where you're deploying artificial intelligence, there ought to be human involvement. And I say the best place to do that is with the output, to be checking it. The problems that we're seeing, other than privacy copyright type issues, are taking everything that's output by these systems at face value without checking them. All those examples I gave you about attorneys putting in fake citations, that would be solved by doing, honestly, a Google or a Westlaw search. are these real cases? Because when they're doing it in those particular cases, they're actually making up the names of the cases as well, not just the law. So it goes to a best practice. That human involvement, to me, is one of the best checks that you can have on the unbridled use of the technology. There's nothing more frustrating to me than getting something back, either from an associate that I'm supervising, because they're all using it too, that's very obviously just like, I know you put this through AI. Like, could you just read it before you turn it into me? Like, it doesn't answer my question. It quotes law from another state. With my students, it might be discussing something that we haven't covered in class. So I don't know if that's human in the loop.
Okay, good question. So here is what AI says.
Yeah, perfect.
Because it's always correct. HITL, human in the loop, is an approach to AI and automation where people stay actively involved in the key steps of the system's life cycle, such as training, supervising, and approaching decisions, rather than letting the system run fully autonomously. So back to the question, it was, do you see that there's going to be a percentage liability where some of the liability falls to AI, some falls to the human involved? And then there was a follow-up question to that with, okay, answer that one first.
No, I mean, it's a good question. I think I'm taking it, and I'm approaching it from the perspective of comparative fault. So what do we assign in terms of the attribution of fault? The legal system, to me, right now is set up to give 100% fault to the human. They're not, I mean, I think the Air Canada case is a good example of that, where we're talking about the chatbot giving something that's wrong. The defense that was put forward was, hey, you know, you shouldn't be relying on a chatbot. The expectation is not going to be that it's right every single time. And the court said, well, no, if you're going to deploy the technology, you need to be prepared to face the consequences. So in my opinion, I feel like at least as we're sitting here in 2026, it's going to continue to be 100% on the human. As we're talking about things like agentic AI or you know, AGI, that may go away. We don't know. I think it's going to be not copyright law, because they're not using AI, treating them as human beings yet. But if we're going to start treating those systems as if they had human level intelligence and thought processes, that might become something where they're going to be looking at things like giving comparative faults between the humans and artificial intelligence. I just don't think we're there yet. I don't know that we're going to be there until, or if AGI, because that's the big one, if it's ever going to exist. Until we get there, we're just not going to know. But everything that we're at least seeing through the courts right now is being 100% that's on the humans. That includes those discrimination cases we're talking about. Like if an algorithm is written, it's a human being that existed on the front end of it, it's going to still be attributable to human error because they're the ones who generated it in the first place. So that's just a prediction. I don't really know exactly where it's going to go, but that seems to be at least where courts are considering and treating things right now.
The follow-up question to that is, I think what they're asking is, with regards to the automated decision-making, would that apply to insurance claims that are going through software screenings? So I think what they're trying to ask is, like, if an insurance claim goes through an automated decision-making that doesn't involve humans,
would they have to be notifying that process is being used? I would say yes. Because, I mean, you think about an insurance claim, right? That requires some level of human input about assessing fault, assessing conditions. I think you can be guided and you can be, you know, persuaded ultimately by that. But that does require some level of human type thought. If you go back to the definition of what ADMT is, it's basically substituting human thought for machine level thought. So yeah, I think that in those sorts of situations, you would be having to disclose that that's being used and that's being deployed because you're substituting human thought. Yeah. Okay, so just some kind of final thoughts on best practices for employers. You know, what we should be doing responsibly as kind of you know, the keepers of this technology. I think first and foremost, understanding the tool is the best. If you're using the technology, learning more and more about it and how to use it ethically, responsibly, safely, that's going to become paramount. And I think that this series is a good way to do that. We're having multiple sessions about understanding these tools because they are very powerful. And it's one thing to throw something into ChatGPT as a time saver. It's another to fully understand like what's going on, like what are the processes behind it, what should I be doing to educate myself on what legal implications there are, what policy implications are. We should be using AI to enhance, not replace. I think the human aspect of it kind of goes back into this discussion about comparative, how much human interaction, how much human input should we be having. I think everything needs to have some level of human interaction, whether it's on the input, the output, or both. Right now, I think most important is what's on the output. We need to be checking and fact-checking all of these outputs. We want to be maintaining privacy standards to the greatest extent possible, and I think that if we're being cognizant about what's going into ChatGPT or any other generative AI, we're serving that privacy interest. Just keep in mind any open source AI you use. Just think about like being in the quad or somewhere in public and just shouting out the information, because that's what the equivalent is. We're taught, there were some ethical rules that came out for attorneys, and it really drove the point home for us when it said anything you put into ChatGPT, you may as well be having an attorney-client privilege conversation on the street. You lose that privilege. So if we're thinking about things from a privacy standard perspective and approaching it from that regard, we're going to be much more responsible about our use of that data and being really cognizant of those privacy issues. You want to be transparent about the use, and I think that goes both ways. If you're using AI, I think that's good to be open about it because you're giving notice. So not only from a legal perspective, where you're giving maybe you're lessening privacy expectations, but also, if you're having students use it, you're having other people, other stakeholders use it, it's also important to be transparent too. And I go back to my thing I put in my syllabus that I almost expect students to use it. And I'm being transparent with them too. I tell them I use ChatGPT for stuff too. It's the smart thing to do, you should be doing it. So as long as we're being open and transparent about it, I think from an ethical perspective especially, we're serving the community as best we can. I think we want to be aware of biases, that this is not a perfect tool. It's an imperfect tool in some regards. So gender or racial biases have been found in different AI platforms. We know that. We have that in black and white with legal cases that have already been working their way through the courts. So just as long as we're cognizant and aware, that kind of goes hand in hand again with the human interaction, how we're using the technology. But absolutely just something that we have to be thinking about when we're using it. Continuous professional development, that's key. That's why we're all here. I think that the more we learn about the tool, the more we're aware, the more that we're using things responsibly. You're only serving yourself better by just continuing to learn. You encourage critical thinking. Don't take everything at face value with what's being put out by these tools. You want to be collaborative, get feedback when you're talking about how things are being used, how we should be addressing the use of this technology, just in general. You want to be open to all of those considerations. Those first few slides that we talked about the various stakeholders on campus and how they're using the technology, critically important to understand and getting that feedback. Some of us may be thinking that some of the ways that students are using it is ridiculous, but there's some value in how they're using it. It's teaching us at the very least how people are going to be using it. Always thinking about ethical considerations, just how am I taking into account equity? Am I being fair? Like, am I over-relying on this technology? One of the things that I'm always trying to be cognizant of, especially in distance education, is how much of a human interaction am I giving to my students? That's an ethical consideration. You always want to seek guidance when needed, learn how to identify AI-generated content. That's another major feature because it's grabbing a lot of people, unfortunately. So again, just all food for thought. I know these are really big picture, like big things, but if you take anything away from just this discussion, it's just to really be thinking like deeply about how this technology is being deployed and used. All right, so I just wanted to end with this. I'm sure most, if not all of you are aware, but the district has a AI use guideline. I think it was very recently published. Yes, like within the last few weeks published. But I took a look at it, and not just because I like you all, but I think it's really good about addressing the do's and the don'ts. I haven't seen it organized in this way, but I really like it. Yes, yes. Yes, you can give yourself a round of applause. You know what, if you want to fast forward, I should have put this at the beginning of this video. If you want to fast forward through everything that I was talking about, a lot of it is encompassed in this. I mean, everything that we've touched upon about the do's and the don'ts, right? Responsible human-led use, using AI tools responsibly and in ways that promote fairness and equity, ethical implications, informing participants when they're using AI tools, all great stuff. And it even for us negative people, attorneys in the room, it's got don'ts, and that we can latch onto those don'ts. You know, don't want to be inserting personal, proprietary, or confidential information. That's one of the main things that we talked about, right? You don't want to use AI tools in confidential or sensitive meetings without approval. How many times have you jumped on a Zoom and you saw Zoom AI was hanging out with you? That's in the last year all the time. Just funny enough, I was doing a deposition not too long ago. An attorney always the attorney that I was opposing always puts on his Zoom AI. The court reporter got on there and just wigged out and said, that's taking my job, how dare you? And you know, at first it was like, okay, that seems like a bit of an overreaction, but absolutely something that is, if we thought about responsibly going into it, like that is that person's livelihood. There's privacy considerations. There's this generated transcript that's just going to exist that Zoom has. Like, am I really wanting all of this available? So just be really cognizant about when the technology is being used, because it might just not be appropriate. You might be in a private situation that someone might be uncomfortable. And then there's some more positive do's for the positive side of the house that are in the twice as positive as you are negative. So where can I find this if I want to get it?
It's actually on the district website.
Okay.
Educational technology, the department. I can send links, but it just got published last night, actually.
Oh, last night, okay.
Yes.
Okay, so.
Hot news, yes.
Hot news, okay. So on the website, on the technology department?
If you just search for AI technology,
Okay.
you can see it.
All right, so if you search AI technology on the district site, it should pop up, this should pop up as one of your first, if not the first result. So this is live and available for you.
We'll publish it as well, or we'll notify. It just got approved, so that's why we haven't really sent any notifications out to our employees.
Okay, so I'm sorry if I let the rabbit out of the hat, but yes. Yeah, I won't take credit for it. I'll give attribution. I'll put the little C with the circle on it. So yes, I encourage you to check that out because it's nice. It's good to have all of these concepts in one quick place to check out. So that is why I copied and pasted it specifically into this presentation. Okay, so I told you I was going to end on a high note, right? So was this photo made by AI? Yeah, I hear a lot of yeses. I don't think any no's. I think we're all sufficiently trained at this point to identify a lot of these things, right? For those online who may not know, you'll see the hands are a little bit oddly placed. So I did these previously, not to try to trick you, but I wanted to end with this one in particular, just because I want us all to feel good about ourselves, that we know enough that this is now obvious, right? 2 years ago, you would have looked at it and your brain wasn't trained enough to like really look specifically at, well, what's in the background? Like, is something misshapen in the background? How many fingers are there? That's the number one thing I look for now, how many fingers? So, I mean, it's funny to us now, but I pointed out because we are all using this tool. And we're training ourselves to be able to identify these sorts of issues, right? So you're going to be thinking about all the things that I talked about previously. It'll be second nature to you, in all due time. So just think about this picture anytime you think about me, if you wanted this as a takeaway. All right, so that is everything that I had, but, oh, yuck, disclaimers. I'm just going to throw it out. We have 10 minutes, so I don't know if you have any questions in the room for now. Yes?
As a society, we always look for the first place, the first person, so we don't see most of the time the effort, the creativity, the thinking. So somebody will use AI and got to this first place, and another person being very creative, using all the thinking, will be rejected. It's not worrisome.
Yeah, I mean, so just for everyone, I'll summarize, and I'm probably going to do a poor job in your point, that, isn't it worrisome that we're, not taking things at face value, or that we're looking at things that people generate or use and we're maybe questioning it, or I don't know if I'm articulating it very well back to you. But yeah, I mean, that to me is like a very big ethical concern is, how are we approaching things? Like, are we approaching everything from this is being generated by AI, or is I'm just assuming someone's done something bad and I'm looking for ways to discount whether or not they've used artificial intelligence. Yeah, it's concerning to me. And there's actually like a whole group within a lot of these companies like OpenAI, Google with Gemini, X with Grok, that they have actual ethicists on staff to be thinking about these sorts of things. And how are we addressing things in this age to answer those sorts of questions? Because I think that they are important questions, because as we over-rely on the technology, we don't want to lose the human aspect of it, and we want to approach it from a positive place. So yeah, it's a big concern. And at least they're putting face value, like these companies are, on they're at least giving lip service to it, right? Hopefully they're actually following through on it. But I'll remain positive and say that they're actually doing work. They're not just collecting stock options.
Although I think Anthropic's ethics head just quit.
Oh, okay, well.
Other questions in the audience? Yes.
You were commenting, or there was a part of your presentation you were talking about how if you put copyrighted material in, that then the output is copyrighted. There's a lot of us who create material that goes out to the general public, sometimes on behalf of the college or on behalf of our schools. I've heard, at least just read, that a lot of these AI tools have been accused of using copyrighted materials. Famously, the guy who wrote Game of Thrones said that he was convinced that this particular AI had been trained by his books. Is there any concern that when we're creating material that we're then putting out as college material, that we're actually inadvertently using copyrighted materials? And are there certain platforms that use less of it, or et cetera?
That's a great question. So to summarize the question is, when we're talking about copyrighted material going in and copyrighted material going out, and that there's concern about using copyrighted material without attribution, how widely it's being used, and how can we make assurances to ourselves that what we're putting out is not somehow copyright or protected just because we're taking from multiple sources on the internet. So a lot of the early iterations, like ChatGPT is like the first iteration. Does anyone know what the two largest data sets were to train the first version of ChatGPT?
Library of Congress or something?
Close. Wikipedia. No, Wikipedia, tongue in cheek. Yeah, Wikipedia and Reddit. For those of you who don't know what Reddit is, it's just a bunch of people espousing their whatever views online. I only bring that up to say that a lot of this content, first of all, I think part of it is really, really difficult to ascertain, like where it was first generated. And I bring up the Wikipedia and Reddit examples to say there's a lot of stuff that's not copyrighted that just exists and is scraped off the internet and put into various materials that you then use to create something that's output. Not to downplay the concern, But I think if you're just using materials that you find on the internet and there's not clear attribution and it's not a directly copyrighted source, I think that that's where you run the most risk. So if I created, say, The Winds of Winter Part 2, and it was so clear that I was taking like character names and basic plot lines, that's where I'd be concerned, because I'm taking a directly copyrighted material and putting it into the machine and getting an output. So this is just a really long-winded way of me saying, I think those concerns are valid, but I think the further you get away from actually taking source material and dumping it right in, the more protected you are, because at the end of the day, not to be glib about it, it's all about proof, right? If I brought an action against you saying you took my PowerPoint presentation, which is not copyrighted, we just put a C on there. I didn't copyright this material, okay? But say I did, and I came to you, like, it's a matter of proof. At the end of the day, I'm gonna have to prove, like, my case against you. And I don't think people would be able to successfully do that with a lot of material that exists on the internet. Because a lot of it is not copyrightable on top of that. So there's also the concept of fair use, and I'm going to butcher it, but fair use under the Copyright Act, things that are in the public domain are all fair game. So famously, Steamboat Willie from Disney, I think, is now in the public domain. If you put that and put it into a content generator and said, spit this out, you'd be good to go, because it's no longer copyrighted, it's in the public domain. So there's the big concept of fair use. And also, if someone puts something out and you can say that the intent was that person, have it generally used by the public, then that's another defense as well. Yeah. Yes?
I have a question about ADMT.
ADMT? Mm-hmm.
Because, you know, that it could be easy to not know that that is generated for, let's say, an average consumer or average patient. Are there any possibilities in the future of requiring that a human is involved, not just having to list that this was generated by, you know, ADMT, but that a human has signed off on it or looked at it to protect the end user who is maybe not as savvy and who takes it at face value that this is, you know, this is the way it is, instead of, does that make sense?
Yeah, no, it does. And I'll say this, I think that you're thinking about right where a lot of the concerns are. I don't know if you're following in the news right now, there is a trial going on that's going to affect about 2,000 cases after it about the addictive properties of Meta. Meta's being sued right now. Mark Zuckerberg actually testified this week. There's going to be enough concern piling up about that something that is available on the internet will have to have those warning labels on it, because young people, you know, people who are older, unfortunately, like, fall victim to those sorts of things. I do foresee laws on the books that say specifically that this was human, or there is a human behind it. I wouldn't be surprised if that's something that there's going to be some need to have captions generated on images or videos, specifically written into the law for all of these various reasons. I think the number one place where it's going to be a problem, and the thing that was concerning to me about one of the first infographics that I showed, was people going for mental health and for health medical advice. I think that's got to have some sort of warning or indication that this is not something that's been reviewed by a professional. This is not professional. You know, it's a sick example, but some people thought it would be really funny to train Google to give the AI-generated result for suicide prevention hotline to give the address of the Golden Gate Bridge. There's evil people out there like that. So I think absolutely that's something that's going to have to be part of what we do with industry moving forward, to have those disclaimers on there. Okay. Not that I know of. There's got to be someone in California, right? There's got to be someone in Silicon Valley area who's thinking about that, who's not being persuaded by all the money maybe being dumped into them to go on the other side. But I would really hope that someone is thinking about that from the congressional perspective. It's a little concerning that the White House action plan is now talking about deregulation of it, because there are some crazy things going on. You know, with the example of my wife training AI to do legal work. Like, that's another thing that, I mean, it's like, that seems like it shouldn't be allowed. Not just from a protecting the industry perspective, but that can really hurt people. Yeah, excellent point.
Any other questions in the audience? Yes, Alan.
I'm going to bring up one thing. You brought up your 13-year-old daughter.
Yeah.
Okay. And there has been, over the last couple of years, companies that don't allow 13-year-olds to go on to ChatGPT or all the rest. And I know there's still some. And of course, this does get into the mental health issue for teenagers. Where are we with any of that, and what kind of legal actions are being taken with the age sort of discussion?
I think in the United States, none. There are Instagram accounts available for 13 plus. I know Meta puts that out, that they have, I think 13 through 18. They have specialized minors accounts. Who knows how safe they actually are? I do know that I think in Australia and the UK, they're thinking specifically about outright banning any sort of social media or hand-in-hand, like generative AI use of these sorts of tools for any minor. They're talking about that in real time right now. I don't know why Australia and the UK, but it's maybe because they take data protection online safety more seriously, just in general over there. In California, I know that we don't have anything specific in terms of legislation that's on the books, but there has been talk, and that's why they're looking at this particular case with Meta so closely about at least addressing it with social media. And, you know, I know I've said it twice already, but, you know, with the wheels of justice turning slowly, I don't see 2 years ago, there was no AI legislation that was being proposed. Now it's all over the place in Sacramento. I would think that from a safety perspective, we have enough baked-in protections in the federal law and state law that it would be easy for them to make that leap. We have the Children's Online Privacy Protection Act. We have, I forget the acronym, SOPIPA, S-O-P-I-P-A. We have these laws on the books, and people are cognizant of them. I just don't know if this is jaded. I don't know if there's just too much money in it, like for them to be taking it seriously. But I'm sure that's part of it. But no, it's absolutely something that we should be thinking about, because that graph was very telling to me and a little bit scary that you know, it's the loss of human interaction where I'm seeking ChatGPT for mental health purposes. It was like 15 to 20% of the respondents in the 18 to 24-year-old category. And that was how often do you use it on a weekly basis? So they're seeking it weekly. But yes, the part that's scary to me, and I brought up my daughter because like she's a very smart kid, but it's, to me, the upsetting thing is the lack of independent thought. It's like you could come up with all this on your own, but it's something quick for her to be able to do. So.
Well, the education for us is all about dual enrollment students. We certainly have a number of students under 18. And any kind of restriction that we have on that is going to have an impact on us.
Yeah, absolutely, and it could affect their academic career. Yeah, I didn't think about it from that perspective, yes. And like, how are we able to be fair to those students? So yeah, I'm not aware of anything in terms of age restriction that's like really strictly enforced yet as a law on the books, but I would not be surprised if it's coming, especially in light of what's going on with the social media stuff right now. Yeah.
So I just want to be respectful of everybody's time. Can we give Paul a big hand? That was fantastic. Thank you so much. We really appreciate you coming.
Absolutely.
We will, oh, you got an extra applause. Also, one of the comments was something like, good job, speaker, you have skills that slap. So there you go.
Oh, wow. Skills that slap, all right.
I don't know, Paul, that's what it said. Okay, super happy to have you, thank you. We will make sure that Paul's non-copyrighted PowerPoint gets out to all of you. So we'll make sure you have that. And then I just wanted to say that, you know, throughout Paul's presentation, there was mention about just like that human connection and making sure that we keep that, which is a beautiful segue, because please don't forget that March 6th from 9 to 10 o'clock online, we have Jennifer Wallace, who is like an internationally well-renowned speaker, that she's going to be talking on the topic of mattering, which is a huge piece of what we're doing on this campus as well, in addition to AI. So please join us for that one. And again, please give Paul a big hand.
Thank you. Appreciate you being here.
Thank you, everyone.